my dean at Tulane Law School to make some architectural changes to our building. If American universities can do it in Cairo, we should be able to do it in New Orleans. No, it's a great pleasure to be here. I was here in 1977 for the first time with my parents. A very different time, a very different era, and I still remember vividly being a party of four, my parents, my sister and myself, boarding a flight to Tel Aviv from Cairo airport in the darkness of night. A very scary experience which has kind of stayed with me. And I've been to Egypt in the past few years, and each time I was impressed. There was a new impression, there was a new thing to take back. This is a courageous society. It's a difficult society. You're facing difficult times, which is why I think we need to take all criticism or suggestions or outsiders' views with a pinch of salt, because it's not an easy exercise at all. My presentation will be very much focused on the draft, and I apologize because changes are being made by the hour, it seems, or at least by the day, so it's difficult to stay à jour. But maybe it's not that bad, because the points I'm going to make are of a more general character, and led by an attempt to look at this draft and to think about what I would suggest needs to be done. If you had one or two or three wishes, what are the most important things that come to my mind, and I'll speak to that. A couple of general remarks first. Looking at the draft, and being a German, I see textual inconsistencies. There's a lot that needs to be done just purely, on a purely technical basis. Anyone speaking German might use the word Handwerk, handwerkliche Fehler. You go to a drafting board, drafting exercise, and the result should be a document that is structurally clean, that is internally consistent, that is hopefully, as far as you can do it, and it's a difficult exercise in any setting, but as far as you can do it, it's unambiguous. And I see a number of difficulties there. It's not unusual. I was involved, as the Dean said, in Iraq. That is a constitution that is full of internal inconsistencies. But once constitutional lawyers, and I hope constitutional courts here in the country, sink their teeth into it, structure will matter. It's not, an entirely German obsession. I think the law should be coherent, and more work would need to be done there from my point of view. Second point, inclusiveness. Still a general point, but societies that struggle with diversity, whether it's Iraq, whether it's South Africa, whether it's Egypt, need to be, as far as the constitution drafting process is concerned, as inclusive as possible. Looking at the draft, my greatest concern, comes perhaps at the very end, when the provision on the referendum informs us that it will be a simple majority, as far as I read it. This constitution comes into effect the day on which the people approve it in a referendum with a valid majority of participants. Valid majority. As I read it, because great care was taken on the provisions dealing with the People's Assembly on identifying majorities and defining majorities. Here, a valid majority. So what does that mean? If it means a simple majority of the people, 50% plus a single vote, I would be very concerned. I would expect a higher quorum for the passing of the fundamental law of a country, a constitution, especially under the circumstances that we find in Egypt. Second point related to that, inclusiveness, would be the election system. Article 191 tells us it's going to be a single-member district electoral system, at least in the case of the elections following the effective date of the Constitution. I worry about that as well. Constitutional law, especially if you look at the way that you amend constitutions, constitutional law is not going to be amended terribly often in many countries. Look at the United States with a difficult amendment process. Germany might be an exception. The German constitution has been amended 7 times as much as the US Constitution. Given that it is much younger, but if you take these factors into account, you've had massive, quite considerable constitutional change. But look at Iraq. I mean, very little constitutional change, even though there was a provision that mandated a review of the constitution the moment it was enacted. But nothing has happened. So whatever the structure will be, that is what it's likely to stay for some time. And I will concede I'm a friend of proportional representation, or at least a mixed member system. And I worry about that in terms of inclusiveness, because the experience of the United States, the experience of France, the experience of the United Kingdom tells me that it can lead to trouble. I'm worried about that. Another general point is that the paradigm hasn't really changed. If you look at the 1971 Constitution, the draft of 2012, or the 2012 Constitution, I should say, and this draft, has there really been that turn of a page? I mean, I was in Cairo 2 years ago, April 2011, and you could hear in the Shepherd Hotel, Tahrir Square, and you could feel the energy of this country, the energy of the youth, the desire for change, the excitement. And I look at this draft and I compare it with the 1971 Constitution and the 2012 Constitution, and I look at this draft and I ask myself, where has that gone to? Much of this draft is repetitive and reflects the previous constitutions. It's not transformative. I do not find this a transformative document. And I mean, I walked up the side street from Tahrir Square to enter the university campus, and I saw the images of the martyrs, and I wonder, is this what they suffered for or what they died for? I would argue this is not ambitious enough. Fourth point, general point still, and then I'll come to two more specific ones. A constitution, and this leads me actually to the first specific point, constitutions are generally the supreme law of the land, the highest norm. They are the foundation, and they should contain all the provisions that are of fundamental importance. Looking at Iraq, looking at this constitution, I wonder whether the key features, the core that you need for a system to work constitutionally, to bring to life the values and the ambitions that you have as a nation, I wonder whether this is a complete document. I find a lot of things that I wonder at. Why would we have a provision in 196 dealing with the employees, not the members, the employees of the Shura Council and their transfer to the People's Assembly, and what happens to their degrees, and what happens to their seniority and their salaries and their allowances and their remuneration? That is not necessarily something I would expect in a constitution. On the other hand, I see some gaps, and we can talk about that. For instance, concerning the Supreme Constitutional Court, which is a very short, very surprising provision at the present. I do not know how many members the court has. I do not really know how they are going to be appointed, selected, the whole court, not just who is the president or who is the vice president. I do not know exactly from the Constitution who has access to the court. I do not know from the Constitution what effect its judgments will have. So I worry about the lack of detail in some areas and the extraordinary detail that you find on rather unimportant points that I, as a journal, would like to see delegated to law. Which brings me to the real point here. There are enormous amounts of delegations to law here. So you identify an issue and then there is a delegation. This right will be regulated by law. It will be regulated by law. You find that throughout this document. And of course, you need delegation to law. Of course, you can't put everything into a constitution. Not even the citizen of a European Union with treaties this thick would accept that you can put everything into a treaty or a constitution. But there are some key elements that are missing here. And now comes my first substantive point. A constitution should be the supreme law of the land. Now let's look at this text. Do I find a supremacy clause? Do I find a clear statement saying this constitution, in one form or the other, This could be in South Africa, I'm sure it's in Kenya, it's in Germany, of course, it's in the Iraqi constitution of 2005. This constitution is the supreme law of the land, and, for example, the human rights contained in it bind all legislative, judicial, and executive power, right? It's clear. There is no statement in this constitution to this effect. It is not there. What you do have are little bits and pieces, and they are revealing. And although I'm on camera here, I will, kind of pinpoint one or two of them. Article 176 tells us that the police has to be loyal to the Constitution and the law. Okay? The Constitution and the law. That's what my translation says. So that is one part of public authority that is bound, obviously, to the constitutional text and the law. Look at the military. There's no provision that tells us that the military is bound by the Constitution or the law. It's an interesting contrast, okay? Both are public authorities, both deal with security, one internal, one external. But from my outsider's point of view, as a German, I would say, where is the difference between the police bound to the Constitution and the law and the military bound to the Constitution and the law? On the side, it comes to my mind, just, as an example, that there is a case at the moment which has just started in Germany, where the military, the armed forces of the Federal Republic of Germany, operating in Afghanistan, are held accountable for an attack on a bridge in which civilians were killed, and now the case is about state compensation. So the Federal Republic is being sued by the victims of this attack in the context of a military exercise on the basis of an international mandate in Afghanistan, and there is no question, of course, that the German military is bound by the Constitution and the law and international law, and can be sued, can be taken to court for damages. There's no question about that. Germans, by the way, wonder also about, the special status that is given to, say, places like Guantanamo Bay. There is no doubt that German public authority, wherever it operates, is bound by Article 1, human dignity, because all exercise of public authority is bound by the Constitution and the law. Wherever it operates, there is no space that is left out, whether geographically or in terms of our separation of powers system. So that makes me wonder. Now, it's not that this concept is unknown, because if you take a look at another couple of provisions, it becomes even more complex and more interesting. Article 187 deals with the concept of legal certainty. And it's an important provision because it tells us that pre-constitutional law will continue to operate after the enactment of the Constitution. That's not what I'm interested in. That's necessary and that is important, but I'm not interested in that. I'm interested in the other part of that provision, which says, well, if you want to amend it, or if you want to repeal it, you will be bound by the provisions of this Constitution. You will be bound by the provisions of the Constitution. You cannot legislate in the area of pre-constitutional law without following the conditions, the procedures set out in the Constitution. I say, bravo, yes, I like that. But why do you restrict it to that provision, and why do you not elevate the primacy, the supremacy of the Constitution to a general principle? There is more. Article 126 is perhaps the strongest statement of what I would like. It deals with treaties, and it tells us, without looking into the translation here directly, treaties can only be enacted or can only be enforced or can only be ratified in Egypt if they comply with the Constitution. Well done. Yes, the Constitution is supreme, right? It's the highest law of the land. No treaty can be ratified if it violates the Constitution. Well done. Good. But why not for the law in general? Why not? Why international treaties only? I do not know. But let's take another look at the legislator. Article 69, doesn't really deal with legislation, but it tells us that the state is bound by the law. The state is bound by the law. Why do we forget the Constitution here? Why is the police bound by the Constitution and the law. The military is not bound by the Constitution or the law, according to this draft. And the state as a whole is just bound by the law. Why just bound by the law? Why not the Constitution and the law? That would make sense, I think. If we look at the judiciary, Article 159, and this is where I will just turn a couple of pages, bear with me, and quote. It's the translation, of course. The independence of judges, it tells us. Judges are independent, excellent, cannot be dismissed, I would agree, are subject to no other authority but the law, and are equal in rights and duties. Where's the Constitution? Shouldn't judges be bound by the Constitution? In South Africa, judges are bound by the Constitution. In Germany, judges are bound by the Constitution. In the United States, judges are bound by the Constitution. The leeway they have is different in all three systems, but they are bound by the Constitution. It's the exercise of judicial authority, and they should be bound by it. What is the big deal? They should be. Of course, there's a big deal here. But that's the one provision. If you ask me, you know, what should you do? And again, I apologize for my fairly harsh criticism. It can be explained with 8 years of work in Iraq, where I never get tired, or maybe I do, explaining that a constitution is the highest law of the land and provides the standards for legislation. And if someone tells me, but there's a federal law, tells us what the state of affairs is, I answer, but the federal law could be unconstitutional because the legislator and the judiciary and everyone else is bound by the Constitution. So whatever the product of the legislator, the standard is the Constitution. Let's make that clear. And it is important. It is important. Let me give you, an example. This is one of the gaps I see in the Constitution, but it perhaps, makes this kind of thinking clear. On one of the occasions, these past 48 hours, I had a small exchange, and I was a little rough, I will, agree, but it's this, geez, in the Constitution, it says that the President and the Prime Minister cannot be President or Prime Minister if they do not hold or have or enjoy their civil rights and liberties. Okay, so you can only be President, a candidate, and you can only be Prime Minister, a candidate, if you enjoy your civil rights and liberties. Now, as a German, my instinct, sofort, instantly, is to look for the provision that allows a citizen to lose his civil rights or liberties. If the condition is you must have them, there must be a provision by which you can lose them, because it's so important. Article 18 of the German Basic Law has a provision that says, in very specific cases, under very restricted circumstances, and only by the Constitutional Court, can your civil rights and liberties be taken. And, torture me, I will have difficulties giving you a case, because it's so important. But if you need to have your civil rights and liberties to be Prime Minister or President, which, is a perfectly acceptable provision, you should have in the Constitution a mechanism that tells us how you can lose them in the first place. And the response yesterday was, well, we don't need that because it's contextual, because if you commit a felony and you're convicted of a crime, you lose, or you may lose, on the basis of law, criminal law, your civil rights and freedoms. And that's where I struck back and I said, that is the whole problem. You are interpreting the Constitution with the help of a law, but the law is below the Constitution. The Constitution is supreme. The Constitution should tell us what the law means, not the other way around. You're turning it around. You need specific provisions when you even contemplate taking civil rights and freedoms, and that is one of the crucial gaps. It's a small one, but the logic. You're quite right, 2 minutes. I get excited, I'm sorry. Bill of Rights is magnificent. It's wonderland, because it's so long. The Germans do not have a Bill of Rights like this. We come by with 19 articles, right? 19 only. And this is marvelous. But what I lack, again, and it's a